Okay, I think it is live now. Right. So we are now going to discuss about the hypothetical questions and what their answers should have been. This is regarding the paper 2 of the patent agent examination that took place just few days ago on 7th January. And before I start with it, one request that you do please subscribe and share this video, because when you do that, it's one of the best incentive for any author to come up with more videos to help you all. So I hope that the kind of love that you have given for the previous video, you'll do the same for this as well. Well, just an announcement that the paper one key, I made a video for paper one also, the answer key, and that somehow got deleted by the developer. But that's okay. Like everybody says that nothing to regret. Whatever happens, happens for the best. So I'm here now to give you the answer key for the paper two of this patent agent examination that happened on 7th Jan 2024. So the first question is, it's a 5-mark question. When it comes to delimiting the area of monopoly claims, the patentees were as usual between Celia and Cheribis. If they stated their claim too widely, the invention would sink in the sea of prior art knowledge. If they stated it too narrowly, it would be lost to the pirates. So basically, it's a very intelligent question drafted. There is a story of two monsters, Celia and Cheribis, where these monsters um, uh, are so close to each other. One, let's say, is to the left, to the right is another one. And if you move a bit to the left, you'll be caught by monster Celia. If you go a little bit to the right, you'll be caught up by another monster. So in that regard, they have highlighted about the Patent Act and the claim drafting skill set, that if you try to claim it broader, then you might end up claiming it too broad that your patent application might just get rejected. The second is about that if you try to narrow down your claims, it might get too narrow that the pirates could just design around and come out of any infringement issues. So in that regard, a question was asked, and a student had to think about this statement and identify some of the best practices with regard to drafting of claims for the application of the grant of a patent. So this is not something which is as per the previous year questions that we used to get. It's a very smartly designed question, a very generic one, and it really tries to bring out if you really know about claim drafting at all or not. So some of you who I talked to had written about section 10, subsection 4 and section 10, subsection 5, because that's more related to claims. They should be supported with the specifications. But I think the better answer should have been if you could quote some examples and the best way to claim your invention. So first could have been a topic of never claim a genus over a species. So genus over a species claim is like, and you could explain a bit that where somebody is trying to claim a bigger component where specifically something is already known in the art. For example, imagine a steel is already known in the art, and later on someone comes up with a claim to claim metal per se. So this metal will anyway encompass steel. So such kind of broader genus over the species claim should be avoided. The second strategy is to claim possible modification, because for an inventor, it's not possible to invent every particular modification that an invention could evolve through. So one has to imagine certain such possible scenarios, situations, and try to claim it. For example, let's imagine, and this example could be given, there could be several other examples. For example, a claim is on pen and a conically shaped eraser combination, wherein one end of the pen is glued to an eraser. So this particular claim is quite narrow, and further modifications could be that someone could invent, instead of a conical eraser, they could come up with a triangular eraser or with any other shape of the eraser. So why claim only conical shaped eraser? And this claim is about pen and the eraser which is connected to each other through a glue. And somebody could just invent around, design around, and say that, okay, I'm just force fitting the two. So in order to cover up these modifications, what could one could rather say a pen and an eraser combination, wherein one end of the pen is attached to an eraser via insertion or through a glue. So you remove that conical part and you make it a little broader. And also instead of pen, you could say a writing device, so that pen and pencil both are covered. So this is called as where you claim possible modifications basis your imagination, and then maybe you can later on file more detailed information about when you actually reduce it to practice. The third is about writing claims in the style of a Jepson claim, which is two-part claim, wherein very clearly you identify the differences between the prior art and your own invention. So you first claim a prior art in the preamble, then you use the word characterized in that, and then you detail about your own invention. So that is where it's a clear demarcation or distinction between what is there in the art and what you have invented, so that you don't fall prey of reclaiming what is already in the prior art. So this was a very broad question, and the answers could be therefore articulated in different manner. But this is something which I thought could have been a possible answer. So anyway, the next question is about Aryabhat Aerospace Limited, that designed a new and inventive aeroplane wing, filed an application with a grant of patent wherein angle of attack of wings claimed was between 50 to 60 degree. However, during the prosecution, the said application further research established that the best optimum results were obtained with an angle of attack when the wing degree is between 70 to 73, keeping all other design parameters same. What would be the possible way to protect the optimum angle of attack found later on? So a straightforward question and a straightforward answer. The option one is about filing patent of addition, because this is something that you found later on. So it's an improvement where you find 70 to 73 degree vis-a-vis 50 to 60 initial degree that you came up with. So patent of addition section 53 to 55 that could be quoted, and that patent of addition doesn't require any renewal fee, and that it expires on the same day. Some information about that. Some students have also given another option about filing amendment under section 57, section 13, and the relevant um, form 13. So two options exist, and you could mention both the options. The third question is about Mr. Chandra, who is doing his master's thesis at Ramanujan University of Science and Technology. He, along with his professor Chanakya, made an invention having no IPR policy in place. A patent application was filed and granted with Mr. Chandra as applicant and Mr. Chandra and Professor Chanakya as inventor. Later on, university took your help as a patent agent in forming their own patent policy, IPR policy, and realized that patents generated in the university campus, even in the past, should be on their name as applicant. What is the prescribed procedure and documentation required for bringing the name of the university as an applicant in Mr. Chandra's granted patent? So, and specific section and rule and forms had to be provided. So I think the answer lies in section 69, wherein assignment could be taken from Mr. Chandra, where he assigns the invention to the university, and then both of them then register this assignment in record, duly filed with the patent office. Rule 90 and Form 16 are the relevant rules for it. So, and the relevant fee that you had to provide. 1600. So the next question number 4, is about Ms. Gargi, who is an inventor who filed an application for the grant of the patent along with the provisional spec as an applicant with the patent office on 11 Jan 2023. Afterwards, Ms. Apala joined Gargi's research project and assisted her in finishing it. Once they finished it on Jan 8, 2024, she plans to file a complete spec, wherein she wants to include name of Apala in asking which form would be needed. So it will be Form 5 plus Form 1 at the time of filing, complete specification that the name of Apala would be included. And the second question is about Ms. Apala would like to have her name mentioned in the letter of patent also, which is the patent certificate. So it will be Section 28, Form 8, fee as 800 rupees that had to be provided as an answer. Part B, question number 5, which is of 10 mark. Recently, Jan Vishwas Act has been promulgated, and the question is about what are the objectives and what have been the amendments. So basically, the objectives are of this Jan Vishwas Act is to decriminalize petty offenses, is to reduce burden on the judiciary, and to boost businesses grow and to enhance or encourage investments. So these are the basic tenets of the Jan Vishwas Act that you had to write as objectives. And then you had to mention from rule section 120 to 124, whatever amendments have taken place in the form of a table. So you put your old section and you put the new section. This we did quite detailed one in the class itself, and I'm happy that it's 10-mark question that came up. So I am very sure that this should have been very easy for at least my students to answer. Anyway, so the next question is about question number 6. Mr. Sudama filed an application for the grant of patent for his invention Cycle Dynamo on 19/5/2012, which was granted and recorded in the Register of Patents in 2016. Due to engagement in some personal emergency, he missed to pay the renewal fee. So he has asked for a professional advice. There is scenario 1. Sudama missed the timeline for payment of renewal fee by 5 months. So the answer was simple. It is basically rule 142.2, where extension of 9 months is also available. So once 3 months is over, you still have time period of 9 months to ask for it, the extension to file for a fee. So it's just still 5 months that he missed it for. He still has another time period of 4 months under section 142, subsection 2. The second is about that what if he missed the deadline by 14 months? So certainly the relevant section is section 60, the restoration of lapsed patent, where within 18 months he can file under Rule 84, Form 15. By filing a relevant fee of rupees 2,400, he can ask for a restoration of lapsed patent. Situation 3 is when he missed the deadline by 25 months. So certainly this is very easy again. He will definitely lose completely his rights over the patent. Another question asked was what repercussions might an applicant face due to non-payment of renewal fee concerning their patent application. So if the patent has been lapsed because of non-payment of renewal fee, then certainly anybody who starts to use the invention, you cannot stop him. You cannot sue him in the court for infringement. So during this time period of when the patent, you did not file the renewal fee on time and it lapsed until the time it was brought back in the force. During this time period, anybody can put your invention to the market, you cannot sue him, and maybe you might have to pay a person who already started to use the invention and invested quite a lot. So this was the answer. Question number 7 is about Dr. Ranjit, who developed innovation based on green algal technology. So basically this whole situation is about one wonderful technology, which is environment friendly, which reduces air pollution, that comes to the notice of Government of India, and they want to acquire the patented invention. So it's an acquisition. So certainly some of you who I talked to had written about section 100, but I don't think it's the right one. It should ideally be section 100, section 102, which is about the acquisition of the rights or acquisition of the patent by the government, and where government has to pay the royalty amount to the patentee. They have to both sign a contract or a agreement. But if in case this agreement is not is rather onerous and the patentee is not happy, they can definitely go to the court, and the entire procedure is listed in section 103. So 102, 103, and some of you have also listed certain sections of 100. But I think most pertinent sections are 102 and 103. So I think, yeah, this is about my set of, update on what could have been the possible answers. Then there are set of other questions which are on drafting, but for that, I think we need a detailed class, and I'll talk to my students in the class itself. But this one I wanted to do for a broader audience to benefit them all. So once again, I would request before I close the video to definitely please do subscribe and share it ahead. Thank you so much and all the very best.